Greetings and welcome to Searches and Seizures, the Return of Property from American Jurisprudence. We're going to have, of course, Black's Law Dictionary at our side. Looks like we're working with 9th edition. We'll zoom this in a little bit for clarity here. And let's get started here. Our text for today will be from American Jurisprudence. This will be the 2011 2nd edition, Searches and Seizures. We're going to be starting at section 312, and this is regarding return of property. Let's get to it. So, section 312, generally, return of property. The federal rules of criminal procedure provide that a person aggrieved by an unlawful search and seizure of property, or by the deprivation of property, may move the district court for the district where the property was seized for the property's return. By rule, the court must receive evidence on any factual issue necessary to decide the motion. If it grants the motion, the court must return the property to the movant, but may impose reasonable conditions to protect access to the property and its use in later proceedings. State statutes also provide that a defendant aggrieved by an unlawful search and seizure may move the court for the return of property, the possession of which is not otherwise lawful. Observation. Documents obtained by subpoenas, duces tecum, do not constitute property seized within the meaning of a procedural rule which allows seized property to be returned to its owner because subpoenas themselves are not seizures, and thus such a provision does not provide the trial court with authority to the return of the documents. All right, what is this here? This duces tecum or whatever. Let's find out how to say that, and let's head over to Black's. Yeah, Latin's not my my best language. Let's see here. We're almost to the D's. Bear with me here. This is a scanned edition. It'll catch up in a moment. In the meantime, please hit the like. Make sure help out the algorithm get these notifications out. Seems like I didn't even get a notification yet. They usually come pretty quickly. All right. I gotta move quicker than that. All right, here we go. Well, we're in the D's, but it's at the end of the D's, so let's see if we can get there a little quicker. All right, here we go. Now we're near the end of the D's. Oh, DC deuces, here it is. Duces tecum, also tecum. Tecum or tecum, you decide on that, but the first one is duces tecum, or duces tecum. I guess tecum works. It is the first one here. Duces tecum. Latin, bring with you. See subpoena, duces tecum. Duces tecum. Under subpoena. Oh, great. Okay, so we understand here that it means bring with you. So it's a subpoena that you bring with you. Let's see how that applies. So, because subpoenas brought with them themselves are not seizures, and thus such a provision does not provide the trial court with authority to order the return of the documents. So the subpoenas they bring with them. As a general rule, seized property other than contraband or property forfeited under a specific statute should be returned to its rightful owner once the criminal proceedings have terminated, unless the government has a continuing interest in the property. The government's interest may take different forms as long as it is a legitimate interest. The government may not keep seized property purely for the sake of keeping it, or because it is hopeful that it may be relevant to some future investigation. That's footnote 11. We'll have to check that one out. That's DeLodge versus State. Let's see here. All right, let's get back up to the text. A claimant who seeks the return of property seized pursuant to a search warrant has the burden of proving entitlement to lawful possession of the property. Then the burden shifts to the government to demonstrate a specific nexus between the seized property and the continuing criminal investigation. Although the burden of proof on a motion for the return of property seized during a search is on the movant, while the criminal prosecution is pending, the burden shifts to the government after trial, after a guilty plea, or after abandonment of the government's investigation. Critical one right there, and that's footnote 14. U.S. versus Gotti, 2003. All right. So although the burden of proof on a motion for the return of property seized during a search is on the movement, while the criminal prosecution is pending, the burden shifts to the government after trial, after a guilty plea, or after the abandonment of the government's investigation. The government has the burden of proof to show that it has a legitimate reason to retain seized property, and the burden on the government is heavy because there's a presumption that the person from whom the property was taken has a right to its return. A facially sufficient motion for return of property must specifically identify the property and allege that it is the movement's personal property, that the property is not the fruit of criminal activity, and that the property is not being held as evidence. So there's the criteria there. Facially sufficient motion for return of property must specifically identify these things. Here, this is from footnote 16. And that's referring to Almeida versus State in the Florida District Court of Appeals, 2nd District, 2007. And just remind everyone, this broadcast is strictly for the entertainment educational purposes of the YouTube live stream and the replay. It's not to be used for anything legal, lawful, personal, private, professional, financial, tax, or otherwise. Don't do this at home. All right, so as we continue, we have the, let's see here. Oh, there we go. That the return of property, oh, Lord. All right. Although the burden of proof on a motion, okay, the government has a burden of proof to show that it has a legitimate reason to retain seized property. And the burden on the government is heavy because there is no presumption that the person from whom the property was taken has a right to its return. Facially sufficient motion, here it is. Property is not fruit of criminal activity, and that the property is not being held as evidence. Here's our practice tip. A defendant has no right to effective assistance of court-appointed counsel on a post-conviction motion for the return of seized property, as the motion is civil in nature. Interesting there. No right to effective assistance of court-appointed counsel. on a post-conviction motion. And that's from footnote 17. Let's see what state that was. Wyoming, 2007. All right. That was our practice tip. Once the trial court's need for the confiscated property terminates, the court has both the jurisdiction and the duty to return the seized property. The court in which a criminal charge is filed has exclusive jurisdiction to determine the rights to seized property and the property's disposition. A motion for the return of seized property is properly denied only if the claimant is not entitled to lawful possession of the property is contraband, or subject to forfeiture, or the government has some other continuing interest in the property. The trial court cannot make a determination regarding the government's legitimate continuing interest in the seized property without evidentiary support, which would be cause for an evidentiary hearing if necessary. See, that's footnote 21. And back to Wyoming. Looks like that's a very important holding. Thus, when addressing a motion for the return of seized property, the state must do more than assert, without evidentiary support, that the property was stolen or is not in the state's possession. Affidavits or documentary evidence, such as chain of custody records, may suffice to support the district court's determination regarding a motion for return of the personal property seized at the time of arrest, but an evidentiary determination is necessary to ensure that there is sufficient evidence to support the court's decision. An individual may seek mandamus to compel the return of any illegally seized or wrongfully withheld property taken in connection with the execution of a search warrant, but later suppressed. The summary remedy of a motion for the return of seized property cannot be turned into a civil proceeding for conversion. And that's footnote 25. Ensonic Corporation versus Superior Court, California. That was 1998. The summary remedy of a motion for the return of seized property cannot be turned into a civil proceeding for conversion. In the context of a motion for the return of seized property, a presumption of ownership is created by exclusive possession of personal property, and evidence must be offered to overcome that presumption. Unless another party presents evidence of superior title, the person from whom the property was taken need not present additional evidence of ownership. Let me read that one again. Unless another party presents evidence of superior title, the person from whom the property was taken need not present additional evidence of ownership. And that's footnote 27. And that's State versus Aggie, Nebraska, 2007. So we have some pretty comprehensive outlook here for generally on the return of property. Now let's get into some specifics. Before we do that, let's check on we missed a supplement. Great. So we got some cases here, but these are usually pretty good. Defendant was not entitled to return of his passport, which was seized by the government during its investigation, where the passport was property of the United States government, according to Title 22 Code of Federal Regulations, Section 51.7, U.S. versus Banks. Okay, 2010. In issuing required government to return property seized pursuant to a search warrant for urine samples on which suspicionless drug tests of professional baseball players had been performed, the district court did not abuse its discretion by concluding that equitable considerations required sequestration and return of pay. Well, We all know that that's been a popular case. Neither the state nor the trial court can impose requirements beyond those contained in statute authorizing seized articles to be kept under the direction of the court or justice, and then consider the defendant's refusal to comply with them to be good cause to withhold his seized firearm. Okay. I gotta be careful with some of these case details here, lest we don't get to spread the word of this great jurisprudence here. So we're on to section 313, availability of action in equity. When a person aggrieved by an unlawful search and seizure moves for the return of property seized before criminal charges are filed, the motion is treated as a suit in equity. Observation. The court's equitable jurisdiction will be exercised cautiously and only upon a showing of a callous disregard of the Fourth Amendment, an irreparable injury if the relief is not granted, and a lack of an adequate remedy at law. The requirement that a person prove callous disregard of the Fourth Amendment includes a disregard for the rules governing search and seizure. Footnote 3. In Search of Loreley Corporation in Iowa, 1998, when the government complies with the court's directive to return certain categories of important documents, and all the other seized documents are made available for the aggrieved party's inspection and copying, the mere possibility of harm from the stigma of being indicted is insufficient to show irreparable harm. Practice tip. Defendants seeking the return of seized property that is not the evidence, fruit, or instrumentality of the charged offense do not have to demonstrate that they will suffer irreparable injury if their property is not returned. So if it's not part of the fruit or instrumentality of an alleged offense, they don't have to demonstrate they will suffer irreparable injury. However, mere possibility of harm from stigma of being indicted is insufficient to show irreparable harm. But after being charged, they don't have to demonstrate that anymore. That's what it seems there. As to the right to recovery on the basis of a claim that damage to seized property constituted a taking. See section 322. As to lack of remedy at law, see section 314, which we will be visiting shortly. And here we are, section 314. Denial, when adequate remedy at law exists. A court may deny a motion for the return of property when an adequate remedy at law exists. Practice tip. So let's figure this out here as it applies in practice. Establishing that the defendant has an adequate remedy at law is most often accomplished by establishing that the defendant had the opportunity to be heard during a forfeiture proceeding. When an adequate remedy at law is available, the court may dismiss the motion brought in equity for the return of property, but only if the court is confident that the form at law, which is available, will give the movement both a timely and an adequate forum to assert the same constitutional rights which are being raised in the equitable form. Observation. A party has no adequate remedy at law if there is damage to the subject property that falls under the exception to the waiver of sovereign immunity under the Federal Tort Claims Act. It falls under the exception to the waiver of sovereign immunity. Oof. There's no adequate. Let's see what that falls. That was footnote 4. Matter of one white Jeep Cherokee VIN number in Iowa, 1998, as the exclusions from the Federal Tort Claims Act, see Section 33 and Federal Tort Claims, American Jurisprudence. All right. If everyone's still in there, please give a heads up in the chat there. Let me know that we're still broadcasting through and the audio is coming through clear. Now we're getting on to the fun part here with Section 315, contraband. Jump over here to the chat really quick and see if this is refreshing. All right, looks like everything's working on that end. And you get notifications out there, great. Excellent, so let's continue. Individuals have no property right in contraband materials. So contraband materials will not be returned to them, regardless of whether the initial seizure of such materials was improper or whether any person connected with the seizure was convicted of a crime. For the purposes of forfeiture laws, contraband per se consists of property that is inherently illegal to possess, and derivative contraband consists of property that is not inherently illegal, but is used in an unlawful manner. For contraband per se, no forfeiture action need be filed for the government to retain the seized items, as the government owns the items upon their seizure. To determine whether a claimant is entitled to the lawful possession of property seized pursuant to a warrant, and so entitled to its return, the court first must determine whether the property constitutes derivative contraband. If it does not, the court must balance the competing interests of the government and the claimant, with the test being reasonableness under all of the circumstances. If the United States has a need for the property in the investigation or prosecution, its retention generally is reasonable. But if legitimate interests of the United States can be satisfied even if the property is returned, its continued retention is unreasonable. And that's from footnote 6. That's a matter of property seized from ICS Cutting Tools in Wisconsin, 1995. Cutting tools. Okay, so do you guys think that cash could be considered derivative contraband if it's being used in an unlawful manner? Pipe up in the comments. Let me know what you think. To determine whether a claimant, here we go. No, for contraband per se, no forfeiture action need be filed for the government to retain the seized items, as the government owns the items upon their seizure. So contraband per se, not necessarily a derivative, but to determine whether a claimant is entitled to lawful possession of property seized pursuant to a warrant, and so entitled to its return, the court must first determine whether the property constitutes derivative contraband. If it does not, the court must balance the competing interests of the government and the claimant, with the test being reasonableness under all of the circumstances. If the United States has a need for the property in the investigation or prosecution, its retention generally is reasonable. But if legitimate interests of the United States can be satisfied even if the property is returned, its continued retention is unreasonable. So here we have derivative contraband includes tools or instrumentalities that a wrongdoer has used in the commission of a crime under statute authorizing disposal of contraband articles seized in execution of a search warrant or other authorized method. And that's New Hampshire State versus Cohen, 2006. Grounds for suppressing evidence. See evidence. ICS Cutting Tools. Wonder what they were up to. So cases. State bears the burden of proof as to whether seized items is contraband under statute authorizing disposal of contraband articles seized and kept under the direction of the court or justice. All right, and that takes us on to Section 316, generally. An action for damages lies against a person responsible for an unlawful search and seizure in violation of the Fourth Amendment. So, action for damages lies against a person responsible for an unlawful search and seizure. Tort action resulting from an unconstitutional search and seizure may be brought directly under some state constitutional provisions. But such a federal action requires some conduct amounting to a search or seizure within the meaning of the United States Constitution. Practice tip: the defendant challenging a search conducted by a private party bears the burden of showing that the search was governmental action to seek remedy against the government. When property damages result from a seizure by state officials, plaintiff may state a Fourth Amendment claim in addition to a procedural due process claim. That's footnote 5, Fox versus Oosterom, and that's in Michigan, 1997, and in Farm Sixth Circuit in 1999. Observation: the extent of proof required on a suppression hearing differs from that needed in a civil action. So a ruling suppressing the property which has been seized by officers is not res judicata in a later damage action for illegal search and seizure. Where an initial seizure of property was reasonable, defendant's failure to return the items does not, by itself, state a separate Fourth Amendment claim of unreasonable seizure. So where it's reasonable, defendant's failure to return the items does not itself state a separate Fourth Amendment claim of unreasonable seizure. Interesting again, that's number 7. Shaw versus Cherry Valley, Springfield, something school district, and that's Second Circuit, 2004. And we're on to Section 317, exemplary or putative damages. If the wrongful search is inspired by malice, exemplary damages, in addition to actual damages, may be awarded. Even if express malice or ill will is not shown, exemplary damages may be recovered by the plaintiff for the wrongful invasion of his or her home for a search if the wrongful act was wanton and reckless and in disregard of the plaintiff's rights. In mitigation of such damages, however, the defendant may show the act was done in good faith and without malice. That's footnote 3. That's Caruso versus Forsland, Connecticut. 1994. And then this one here is McClurg versus Brenton in Iowa, 1904. So read that again then. This is this is for exemplary damages. In mitigation of such damages, the defendant may show the act was done in good faith and without malice. But that's up to the defendant to show that, right? Okay, we're on to Section 318, attorney's fees. The Civil Rights Attorney's Fees Award Act allows the prevailing party in civil rights actions to collect attorney's fees from the losing party. Awards have been made under the statute to plaintiffs who were victims of unlawful searches and seizures. As a general proposition, a prevailing plaintiff is entitled to a fee award unless special circumstances render such an award unjust. Practice tip: defendants are entitled to recover a fee award when the plaintiff's claim that his or her rights were violated by an unlawful search and seizure is found to be frivolous, unreasonable, and without foundation. Footnote 4. That's a few of them here. We have this Steinel versus Warren, Seventh Circuit, 1985, Prochaska versus Marco, 1980, and Della Pietra versus New York State Organized Crime Task Force, 1986, in the Western District of New York. Fun stuff there. However, that a defendant against whom an action involving an illegal search and seizure is brought defeats the action does not mean that the defendant is entitled to an award of attorney's fees if the action was not frivolous or unreasonable, or if the plaintiff was partially successful but did not recover any monetary damages. So I guess they can't get too hopeful about always getting paid, the attorneys, huh? Right. Now we're on to Section 319, generally, Federal Civil Rights Action. Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws is liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. A warrantless arrest without probable cause violates the Fourth Amendment and forms a basis for a Section 1983 claim. This is footnote 2. That's Payne versus DeKalb County, Northern District, Georgia, 2004. If, in an action under this provision, the plaintiff can establish that his or her rights were violated by a deliberate pattern or practice of constitutional violations by the police, they are entitled to injunctive relief. Practice tip: the doctrine of respondeat superior is not applicable in civil rights action for the deprivation of rights. Footnote 4. As to respondent, see generally employment relationship. Okay. So it must have something to do with employment. We'll hold off on that. That'll be for further research. The Fourth Amendment's unreasonable searches and seizures clause cannot fairly be read as requiring compensation for damages sustained as a result a violation of that clause, and thus cannot support a claim for damages under the Little-Tucker Act, which provides for a civil action or claim against the United States not exceeding $10,000 in amount founded either upon the Constitution or any act of Congress. That's footnote 6 as Taylor versus U.S. Wow. 8th Circuit in 2001. Good stuff, and now we're on to replevin and trespass, Section 320. And let's check on to the chat. If any of you are still here, please hit the like. And let's continue. All right, replevin and trespass. The victim of an unlawful search and seizure has available the remedy of replevin to repossess the articles taken, and may also be awarded damages for its wrongful detention. Moreover, the victim of an unlawful search and seizure has available the remedy of trespass, and he or she can receive both compensatory and punitive damages for the trespass. Although the constitutional provisions for prohibiting unreasonable search and seizure are applicable only to government officials and not to private individuals, an illegal search by a private individual is a trespass in violation of the right of privacy and constitutes an actionable tort. Footnote 4, Sutherland versus Kroger Company in West Virginia, 1959. Ooh. Practice tip. In mitigation of damages in a trespass action for a wrongful search, however, circumstances tending to arouse reasonable suspicion, for example, that stolen goods were on premises, may be proved. Now it looks like that's that same case from 1959. Circumstances tending to arouse reasonable suspicion. Boy, that's a lot there. Circumstances tending to arouse reasonable suspicion, for example. How can that be proved? That's a lot to prove there. Well, I guess really not. Actually, that's easy because there's just circumstances tending to arouse a reasonable suspicion. Jeez. Now we're on section 321. Do we miss any special footnotes here other than the case citations? Yes. As an action, see section 325. Trespass. Yep, that's it. And we're on section 321. Mental and emotional distress. Because the search is a trespass in which there is an invasion of the right of privacy, recovery can be had for mental and emotional distress, regardless of whether or not the plaintiff suffered a personal injury. In estimating the damages recoverable for a wrongful search, the injury to a person's property, reputation, and feelings may be taken into consideration as well as the physical disturbance of that person's family. And that comes from Krebel versus Henkel, 1911. Jeez, Iowa. And a few others here, and of course we have the Sutherland versus Kroger, 59. Another one, Delastrius versus Boyce, Virginia, 1929. So well established here. Another one, Schall versus Minneapolis. Another one here, that was in Wisconsin in 1914. So well established here. Think of this mental and emotional distress, reputation, feelings, and physical disturbance of that person's family. Onwards here to section 322, seizure of property as compensable taking. As a general proposition, the seizure of evidence by police does not constitute a taking in the constitutional sense. It comes from a 1989 case of McCambridge versus City of Little Rock, Arkansas, 1989. As a general proposition, the seizure of evidence by police does not constitute a taking in the constitutional sense. Likewise, the damage to personal property seized by government agents for investigatory purposes is not an implied taking for which compensation is constitutionally required, because mere possession does not itself constitute an actual taking. As to what constitutes a taking, eminent domain, which actually would apply to more things than most people would even think about. This might be a good one to check for a future AmJur episode here on eminent domain. Let me know in the chat if you think that would be an interesting one. All right, we're on to malicious prosecution here. Section 323. Obtaining and using a search warrant as a sham for a purpose not authorized by the warrant supports an action for malicious prosecution. Although an action for the damages resulting from the swearing out or causing the issuance of a search warrant is not a suit for malicious prosecution, the same rules apply to both. In either case, the plaintiff has the burden of establishing that the defendant maliciously and without probable cause procured the issuance of a warrant, and the defendant must be the prosecutor or instigator of the issuance of the warrant. Ooh. As actions for malicious prosecutions, we have another AmJur on that. And this is as to an action against a private person for wrongfully procuring a search warrant. Oof. We're on section 324, generally, law enforcement officers and agents. The violation of the Fourth Amendment's command against unreasonable searches and seizures by a federal agent acting under color of federal authority gives rise to a federal cause of action against the agent for money damages caused by the agent's unconstitutional conduct. State courts also recognize an officer who intrudes on the privacy of a home and subjects its occupants to the indignity of a search without a legal warrant for that purpose is liable in damages. And this is Guin versus City of Riviera Beach, and that's in Florida, 1980. Also, we have one Hawker versus Woody in Washington in 1981. So that's for the state courts. A private person may be considered an instrument or agent of the government against whom an action can be brought for an illegal search and seizure if the government knew or acquiesced in the intrusive conduct complained of, and if the party performing the search intended to assist law enforcement efforts or to further that party's own ends. The burden of proving that a private search is a governmental action triggering the Fourth Amendment protection lies on the movement. 1997. So, very important one here involving law enforcement officers and agents. A private person may be considered an instrument or agent of the government against whom an action can be brought. And the private person, right, for an illegal search and seizure if the government knew or acquiesced. And also, was it intended to assist law enforcement efforts, or was it to further that party's own ends? And we continue to section 325, private persons. The operator of a sniffer dog service provided to a high school and the dog handlers cannot be held liable in a civil rights action against them for a search of the defendant's vehicle. A store cannot be held liable in tort on the basis of a respondeat superior when a store employee seizes the defendant without probable cause, because private employers cannot be held liable for their employees' constitutional torts. And we're on to 326, private persons procuring warrants. This is the one we were warned about earlier. The proper remedy for an illegal seizure in a suit against the party on whose complaint a warrant was issued. Proper remedy for an illegal seizure is a suit against the party on whose complaint a warrant was issued. Thus, one who maliciously and without probable cause procures the issuance of a search warrant may be held liable on the theory of malicious prosecution, even if the affidavit or complaint upon which the warrant issued was defective or insufficient, or if the warrant was issued without the previous filing of an affidavit. Jeez. In order to sustain such an action, the plaintiff must establish want of probable cause on part of the person suing out of the warrant. One method of establishing the want of probable cause is the showing of the failure to find the goods sought on the execution of the warrant. Beautiful tip here. One method of establishing, remember, there's a want of probable cause. Well, if there's a failure to find the goods sought on the execution, that's one method of establishing that. The person procuring the issuance of a search warrant may be held liable on a theory of trespass. 1917. And Section 327, consent to search. Consent is a defense to an action for damages for an illegal search and seizure. The prosecution bears the burden of proving that consent to a search has been freely and voluntarily given. The voluntariness of a consent to search depends on the totality of the circumstances under which the consent was given. The burden on the prosecution to show that the consent to a search was voluntary is significantly heavier when it follows a constitutional violation. A finding that consent to search was voluntary is reviewed under the clearly erroneous standard. All right, cases. As with the Miranda waiver, the voluntariness of a defendant's consent to search depends on the totality of the circumstances. And then we have Section 328, consent from a third person. Ooh. Oh, looks like we got to check up with the chat real quick here. And Edward Sawicki asks, would a seizure in the form of false imprisonment inflicted by way of threat of arrest for a crime the officer alleges due to not helping him in the apprehension of a wanted individual? False by way of threat of arrest. It gets kind of back to the part we were at earlier there. The remedies might be a little bit more difficult in that threat. Is that showing up on screen here? Hang on a second. There we go. Doesn't all show up on screen, so I'll read it again. It says at the end here that the imprisonment inflicted by way of threat of arrest for a crime the officer alleges due to not helping him in the apprehension of a wanted individual. So and deputizing someone and then trying to arrest them because they didn't want to take the job. It sounds like there's a lot of ways to interpret that, but out of that, it seems like there's a remedy, but probably not. Seems a little bit more complex than just a straightforward approach of a simple seizure or eminent domain or any of these other kind of features we've been going over here that might be a way to get to a good suit. I know we were looking at something back a ways here, applying to that as far as damages, compensatory in that case might be difficult. Other than that, let's continue on here where we have for consent from a third person. When the government seeks to justify a warrantless search because consent was lawfully obtained from a third party rather than from the person whose property was searched or seized, the government must prove the third party had either actual or apparent authority to consent. Let's see here. Actual authority. To establish actual authority to consent, the government must demonstrate a mutual use of the property by persons generally having joint access to control for most purposes. But to establish apparent authority, so that's called actual authority. Mutual use, having joint access or control for most purposes. But to establish apparent authority to consent, the government need demonstrate only that the officers reasonably believe that the third party was authorized to consent, and that's called apparent authority. Actual or apparent authority. Now it's from U.S. versus Gonzalez, 1998. I'm sorry, that's 97, and then People versus Bull, Illinois, in 1998. see here. Caution. Although husband-wife or parent-child relationships give rise to a presumption of control for most purposes over property so as to follow for third-party consents to search property, that presumption may be rebutted by facts showing an agreement or understanding between the defendant and the third party that the latter must have permission to enter the defendant's room. That's footnote 3, U.S. versus Rith, and that was 10th Circuit, 1999. That's a nice caution there. Third-party consents for search. Presumption may be rebutted by a fact showing agreement or understanding that the third party must have permission. Nice. All right, so good thing to know about consent for third party. Because there's even more than just one kind of consent. Now, Section 329, acting under the authority of a warrant. When a search and seizure is made under the authority of a warrant properly supported by an affidavit and issued after judicial approval, the warrant protects the seizing officer against a suit for damages. We learned this under warrants, American Jurisprudence presentation. Previously, you can check the playlist for that. This principle also protects the officer who executes it, although the warrant is issued irregularly, without an affidavit or complaint upon an insufficient affidavit or complaint. The warrant is issued irregularly, but still issued. Caution, if the warrant appears on its face to be illegal or invalid, or the magistrate issuing the warrant is without authority to do so, then the officer who executes it is liable. Ooh, so this is a big one here. So if it's on its face to be illegal or invalid, if it appears on its face, that's an important one there, or the magistrate is without authority to do so. So they need to know that the one issuing it has the authority to do so, or they're liable. That's Knisley versus Ham in Oklahoma, 1913. Wow. And then we're on to property damage during search. The 4th and 14th Amendments provide a remedy when a citizen's property is unreasonably damaged during a search. The execution of a warrant must be carried out in an orderly manner, and if the officer executing the warrant exceeds his or her authority or wantonly destroys property in making the search, neither the warrant, although valid on its face, nor the good faith of the officer will protect the officer from liability. Observation: in an action for damages for injury done to property in the course of a search, the question is not whether injury was done to the property by the officers while executing the warrant, but rather whether the officers executed it in a reasonable and orderly manner. In the execution of a search warrant, it may be necessary to remove obstructions which prevent the officer from making a thorough search, like a seat cushion, and the removal of such obstructions may result in injury to the property, but the officer is not liable for damages if he or she acts in a carefully and orderly manner and is not guilty of wanton destruction of property. 1939, Moore versus Kilmer. All right. Well, that takes us to the end of this presentation here, because now we're ending at qualified immunity. But this is going to be a whole another topic here. Just to let you guys know that this does go on quite a bit on this, and it takes a topic in and of itself, and the good faith defenses and all that. So we'll say that for the second part. I know we covered a lot tonight, but we did cover some very substantial parts to know about searches and seizures and how they are supposed to be properly executed, utilized, and presented. Again, even when they are legally done, lawfully done, they're supposed to be done in a reasonable and orderly manner. So with that being said, I would like to thank you all for attending. I don't know how many people got the notification. I didn't get one this time, but Craig Carey says he got one, so that's good to know. Uh, I hope, Edward, you get a notification or just found the stream. I'm not too sure, but we'll try to find out. Again, please hit the like so we can make sure that a lot of people will get the notification next time and we can have more people to participate in here. I appreciate the feedback and helping get some clarity to some of these topics because they can get pretty lost in the weeds without keeping some focus on the real purposes behind learning these, is applying them and maintaining protections and the security we have in the common law that no other country in the world actually supports. As weak as it may be having support here, it's up to us to continue to exercise our rights and maintain them for posterity and reciprocate that generosity that was given to us. So, on that note, I'd like to thank everyone for attending. I would like to encourage you to hit the subscribe and the bell notification so hopefully you'll get a notification for the next one. And I will see you on that one. Peace out.